Texas hemp businesses can keep selling cannabis flower and concentrates for now, because this morning a Travis County judge issued a temporary injunction that blocked parts of the state's new hemp regulations while the lawsuit over them plays out in state courts. I'm Nathan Bernier. I'm with KUT News, and I wrote a story about this. You can go check out now. If you want to read the temporary injunction for yourself, it's linked to at the top of the story at KUT.org. But maybe you have questions about it, like how long is this going to be in place and what were the legal arguments behind it? Well, I spent 3 days at the Travis County Courthouse this week following this 3-day hearing. And it was very interesting. I was not in the courtroom, actually. I was 10 stories down in the media room because that's the only place you can get a clean audio signal. And as much as I did want to be in the courtroom, KUT, we had our lawyer make a motion to the court requesting that we be able to record and photograph these proceedings, because you're not allowed to just do it. You can't just walk in there like if it were the Texas legislative meeting or a city council meeting and start filming. You need the judge's permission, and we got that permission. And so because we had that, I really wanted to make sure I was getting all the audio. I didn't want my recorder to fail, and I was sharing that audio online so others could follow along, because this was not streamed on YouTube. These proceedings were not online at all in any other way. But, although some are in Travis County. Sometimes you can catch a YouTube live stream, like for the temporary restraining order hearing, there was one, but not for this. And I spent a lot of time during this listening to Jason Snell, because he's the lead trial attorney for the plaintiffs. He's not by no means the only lawyer on this. There's a whole team of lawyers, and some of them have been working on this case much longer than Jason, but he is the lead trial attorney, so he did most of the speaking. And I was very happy that he could make some time today to talk to me, even though he's at a lawyer conference. But he found a space, and you'll see some people walking past behind him, but that's out of his control. We're just fortunate that he could make time to talk. And I will say, I have put in a request to speak with lawyers for the Texas Attorney General's office who were arguing this case. And those are not typically granted, but you could try. You got to try. That's all you can do. So anyway, let's go straight to Jason. And I just started by asking him, what does this temporary restraining order actually mean?
Well, what it means is that the statute that went into effect in 2019 that allowed hemp-derived consumable hemp products to go onto the shelves that have been on the shelves for 7 years can stay on the shelves. And so certain rules went into effect on March 31st, 2026. So just, a month ago, went into effect that would have and did require a lot of those products to leave the shelves. And really what most of those products were smokable or smokable hemp products, or products that were heated in order to be consumed. Not entirely, it affected other products, but so the law that has been in effect for a long time stays in effect, which is a big win for the industry and frankly for Texans, because as we showed the court, this is an $11 billion industry. So it would have put tens of thousands of Texans out of business, out of jobs, significant loss of revenue for the state of Texas. And so the law stays in effect, and that's the law that's been in effect for 7 years. So the judge ruled that, issued a statewide injunction that allows that to stay in place.
Now, for those who haven't been following like every twist and turn of this, what was the basis of your challenge? The state came out with these regulations for the hemp industry, and the hemp industry certainly didn't like the aspects that you challenged. You mentioned THCA. That's the one that gets a lot of attention because that has to do with prohibiting smokable products. But there was also the fees, and then there were some other provisions as well. Can you talk to me about sort of the four, categories that you were addressing and the arguments you were making in plain English?
Sure. So in plain English, the Texas Farm Bill in 2019 permitted certain hemp products to go onto the shelves and into retail locations and to be manufactured and produced in the state of Texas. There was a push in 2025 by certain legislators to change the law, to change Texas law, to limit the kind of hemp products that could be sold. And it was a limited number of lawmakers, but it got some traction. And despite a considerable pushback from all kinds of Texans, specifically veterans, people all over the state pushed back and spoke out against it. Nonetheless, a bill was passed. It almost went into law, but the governor vetoed it. And that was last summer. So the governor vetoed a law that would have limited the kinds of hemp products that, were allowed to be sold in Texas, even more so than what had substantially changed the law. Well, the Dan Patrick and some other lawmakers didn't like that. And so in right around the end of last year, the rulemakers started promulgating, or the process of promulgating, rules that would have that essentially tried to do what the governor vetoed. And so these rules went into effect March 31st. So our argument to the judge, and we believe we were correct, is that the statute tried to do what the lawmakers couldn't do. And there were three aspects of that. First of all, the rules would have changed the testing protocol for hemp products that were allowed to be sold in Texas. And so it's a complicated process. It's not really very easy to explain, but the new testing methodology would have tested products in a manner that the products that are legal would have become illegal. And some of the things that we showed the judge, bath bombs, ointments, roll-on ointments, serums, even dog food, mints, things like that, those would under the new testing methodology, in all likelihood, would have been illegal, whereas before they were legal. So that's one thing that we challenged, is this new testing protocol. The next thing we challenged are the registration fees. So, up until these new rules went into effect, in order to open a retail location, for instance, it was like $250 per year per location. Well, the new fees that went into effect were $5,000 per location. And it doesn't matter if you have one owner of a number of locations, so it's per location. So that's $5,000. To be a manufacturer, the fee went up from something like, I don't remember, $500 to $10,000 per year. And so that's a significant barrier for businesses to get into the lawful hemp business. And we were able to show the judge that those fees weren't really tethered to any administrative cost that the state bears with respect to its administration of the lawful hemp program. So our argument was just that was a draconian fee, really designed to put the hemp business out of business. And so, our argument was that it was unlawful for a number of reasons. The next aspect of it that we challenged were the regulation of products that the hemp industry uses to manufacture their products. So the import of certain kinds of products that you would see on the shelf, such as the bath bombs, the ointments, things like that. The way that Texas, the rules were trying to regulate those would have prevented those from entering into the stream of commerce or entering into the manufacturing process, which would have crippled the industry as well. And then finally, there's another category that the rules would have done, and that is for violations of any of the new rules that went into effect. There's a daily penalty that would have been charged for violators. That would have been a daily penalty with no notice and opportunity to cure. And so we challenged each of those categories of rules on three different bases. Mm-hmm. And so I can talk about those three legal, or those three challenges in more detail if you'd like.
Yeah, I would. Just real quick, I want to hop in, you were trying to remember the number. I know you got a lot to keep in your temporary memory. It was 200 for manufacturers. It went from 250 to $10,000, a 40-fold increase, right?
Right,
What,
right.
what,
That's
what
right.
was, tell me about those three categories on which you challenged these.
Sure. So the first category of challenge is something just called ultra vires, and that is when a rulemaker in this context or rulemaker exceeds what the rulemaker's authority to do. And so in this context, state agencies can pass rules to enforce laws. I mean, that's the plain law. But a state agency cannot pass a rule that changes the law or that exceeds what a law says. So if a law or a statute allows for one testing methodology that is the entry barrier for a hemp product to get into the state of Texas, a rulemaker can't change that what that test is. So, and that's what they tried to do, and that's ultra vires. So that's exceeding a rulemaker's rulemaking authority. And so we challenged each of those four categories on that basis, and the judge agreed with us. The next basis was something under the Administrative Procedures Act. We argued that the rulemakers or the state agencies in this context did not comply with the Administrative Procedures Act. So there's certain things that the agencies or the bureaucrats must do before they promulgate these rules. They've got to post the rules for public comment. They've got to give a reasoned response. They've got to do some impact studies to explain the economic impact. And then they've got to, there are other procedural hurdles that they must jump through under the Administrative Procedures Act in order to pass these rules. And we were able to show the judge that they didn't do those things. And any effort that they arguably did was really just a cursory effort, and it wasn't what we call reasonable compliance. And finally, we argued to the judge that these new rules were just plain unconstitutional, that these fees were operated as taxes, and state agencies and the bureaucrats don't have authority to impose new taxes. Only the legislature does. And we showed that these daily compounding fines that I mentioned a moment ago, that those were unconstitutional. Those were excessive fees under the Texas Constitution. So those are the three bases that we brought forth to challenge these new rules, and we were successful in every category.
Right. And now everyone involved in this in the industry, I think, is looking ahead to July 27th when
Right.
the judge set a date for a trial on the merits. I think there is an expectation that the state will appeal the temporary injunction. And so how do those timelines play out between the trial and the temporary injunction? Kind of what are the possible next steps in this process?
So that's a great question. When you see the trial date in the temporary injunction order, that's really a placeholder. In order for an order of that nature to have lawful effect, it has to have a trial date. And Judge Lyttle picked a trial date, which, if there were no appeals, the case could possibly go forward to a trial. Now, that would be a really quick trial, but we could do it. In reality, that trial has almost a 0% chance of happening. The parties are already preparing their appellate briefs. So this case is going to go up on appeal. Probably, well, parties will start filing things on Monday morning, and if not over the weekend. So that trial is not going to go forward. I can't imagine it will. And the next fight will be in the appellate courts.
And how soon could that happen?
Well, the briefs, like I said, will get filed very soon. We're already drafting them. We're up till early this morning working on briefs. I wasn't, but other members of the legal team were. So you can expect to see some action in the appellate courts very soon. Uh, Before we actually start getting opinions and decisions from the appellate court, I don't know, it could be numerous weeks or possibly months. So we're a bit out from actually getting decisions from the courts at the appellate level. So it's going to take some time.
Right. I think business owners are trying to figure out how to plan around this, and there's a lot of uncertainty. And I mean, there's only so much you can know in terms of the timeline, right?
Exactly. I mean, there's been considerable confusion in the marketplace, and we showed Judge Lytle that since March 31st, when the rules went in effect. And I'm certain that both consumers of products and business owners in the hemp industry are probably feeling very uncertain, and they really don't know what to do at this point, I think. But I do know this, as of this morning, until there's further, some order from some other court, Judge Lytle has stayed the enforcement of those what we consider unlawful rules. So at least there's some certainty in that for the moment.
Does the strength of the arguments during the temporary injunction hearing that occurred this week uh, offer any preview of the strength of the arguments in an appeal of the temporary injunction or a trial on the merits? I wonder, like, for example, I noticed that the plaintiffs, you all brought several witnesses, and the Attorney General lawyers had one witness. It was Dr. Timothy Stevenson with the Department of State Health Services. What do you make of the case that the state made during the hearing?
Well, you're right. I mean, the bulk of the temporary injunction hearing was spent on our witnesses, and that's really not for the lawyers. It's not surprising and not unexpected because we're the plaintiffs and we have the burden of proof to show the judge that a likelihood of probability on the merits of all of our claims that we're likely to prevail when it does go to trial. And there's other hurdles we have to jump through at that time that we're likely to suffer irreparable harm and there's no adequate remedy at law, which means if the injunction is not entered, we're going to suffer harm and there's no court can remedy that harm. So it's harm that cannot be fixed or repaired by a court. So it's our burden. And so it's not unusual that the plaintiff in this instance would put on more evidence, and so it wasn't surprising. Now it does give you a sense that at that stage there was a very fact intensive stage of the fight. Okay, so we have the burden of putting on facts, showing the judge evidence of those things that I just discussed. Now, once we get beyond this fight, it becomes really a legal fight. So the facts are important, and it was our burden to establish the record. But from here on out, it's really based on the law, and that's really where the state is. They're going to be able to lean on the law in the state of Texas, and here we go, right? I mean,
What
we
do you
live
mean
in.
by that? Like the difference between the facts and the law, the case going from more fact-based to more law-based?
Well, once you get up into the appellate level, the facts are what's in the record. So what has happened in the trial court up until the point that you get up on appeal. Once the facts are in the record, it no longer becomes a factual fight. It's just a legal fight. It's a fight solely premised on the law as applied to the facts that are in the record. Now, there are times whenever an appellate court can send a case back down for additional findings of fact. That's unusual. So we're off into the appellate world where it's the law that really matters a whole lot less than whatever facts are in the record. I mean, a whole lot more than the facts that are in the record. So you're not developing more a factual record in the appellate court. You're just the attorneys are briefing and explaining to the appellate court who should win based on the law as applied to the facts.
And by the law, do you mean like case law or just the statute itself?
Both. So,
Yeah.
you look at case law, you look at the statute, you look at the rules, you look at potentially legislative history, all of the rules, the legislative history, um, the whatever it is in the legislative record, courts can look at that. So that's where we are.
During the temporary injunction hearing, the Texas Attorney General lawyers were bringing up websites of some of your plaintiffs and asking Dr. Stevenson to read off descriptions of the products and discuss, THCA. They asked him, what is batter, what is these different hemp products, and it seemed like they were trying to make the point that people are using these products, they're smoking or vaping them to get high. And I was confused because, I didn't know that you were claiming that that wasn't happening. And I have put in a request to speak to the state attorneys, but the policy over there is, I can't just call them up like I can with you. It's a little bit
Right.
harder. But what do you make of their arguments and the line of questioning with Dr. Stevenson?
Well, it wasn't our argument at any point during the temporary injunction hearing that people cannot purchase these products, and then at some point some people can utilize some of these products in order to get high. And that was not our argument. Our argument is, for the reasons I just explained, the rules were illegal. Okay. And so for the three reasons that I just explained, the argument that people could be purchasing these products, and some I'm sure do purchase these products to get high, is really a policy argument, is really an argument that this shouldn't be allowed in the state of Texas, that people should not be allowed to purchase hemp products in order to get high. That's just not something that we want in Texas. Well, our argument, I explained this to the judge in my closing argument, is that is a policy argument that is fought at the Capitol. That's an argument that the lawmakers hear from their constituents, and they vote on laws to either pass them or not pass them, and the governor vetoes them or doesn't veto them. That wasn't something that Judge Lyttle needed to decide, but you heard a lot of that from the state, and that's really, in our view, that's really what this is about. The state doesn't like that, or at least some lawmakers don't like that. Dan Patrick doesn't like that. And so that's why these rules went into effect. And Nathan, that really goes to our point. Our point is, if the bureaucrats are passing rules to change the statute on policy reasons, that's illegal. You can't do that. If we want to change the laws for policy reasons, we can't allow bureaucrats to do that. We've got to go to the Capitol and change the law at the Capitol. That's how it's done. And that really underscored our argument. I tried to emphasize that in my closing argument. And there's no doubt about it that some people do buy these products to get high, just like some people go to a liquor store to buy beer or liquor to become intoxicated. I mean, that's the reality of it. And if you look at Governor Abbott's order, or his proclamation that got into evidence, his order references the fact that consenting adults in the state of Texas who are over 21 should be able to consume products responsibly and legally, and there should be rules that are in laws that allow consenting adults who are over the age to do that, just like they can do that with alcohol and tobacco.